So in the last session, we have started with the part 3 of the Indian Constitution, that is the fundamental right, in which we discuss Article 12, which defines state, in which we discuss what all come under the state. We discuss the three case law of Rajasthan Electricity versus Mohanlal, G Telefilms versus Union of India, in which we discuss that BCCI will not be considered as a state for Article 32 of the Indian Supreme Court. It can be considered as a state for Article 226 of the High Court. Then we discuss A.R. Antule versus R.S. Nayak. Then we discuss, in which we discuss that whether judiciary is a state or not. Then we move to Article 13 of the Indian Constitution, that is laws inconsistent with or in derogation of the fundamental right are void. Then there we discuss Doctrine of Severability and the Doctrine of Eclipse. Then we move to Article 14, that is equality before law. We talk about Article 15, that is no discrimination. We discuss the case laws. Then we talk about the Indra Swane versus Union of India judgment. Then we came to Article 16, that is equality of opportunity. And then we came to Article 17, that is untouchability. Article 18, that is title, abolition of any kind of title. Then we came to right to freedom, in which we discuss Article 19. We discuss freedom of speech and expression, the reasonable restrictions. Romesh Thapar versus State of Madras we discuss, in which it was held that Indian press will also come under the freedom of speech and expression. We discuss right to know, right to remain silent. Okay, then we discuss Rea Singhal versus Union of India, freedom of assembly, right to take out procession, freedom to form association, freedom of movement, Kharak Singh versus State of UP. And the last article that we discussed yesterday was Article 20, that is for the conviction of the offense, in which we discuss that ex post facto law. We discuss with the examples. We discuss double jeopardy, in which we taken the example of you all. Then we discuss the last case, that the last article of 20 clause 3, that was self incrimination. Now we start with one of the most important article of the Indian Constitution. The most important article of the Indian Constitution, that is Article 21. So Article 21 is the right to life, personal liberty, and the right to die with dignity, that is passive euthanasia. Most of you are Clat aspirant. Most of you have done the passage on passive euthanasia. That is the same concept here. So right to life, Article 21 is the right to life, which is the article which is being used by the Supreme Court, High Court, by the petitioner in various petitions. Recently we had the various cases regarding COVID-19, in which Article 21, that is right to life, was used. So Article 21 states that no person shall be deprived of his life or personal liberty except according to procedure established by law. Now, why this except according to procedure established by law? This provision was introduced for the death penalty. Article 302 of the IPC, which talks about, you don't have to remember Article 302 IPC, that you will be needing in the law school. So Article 302 of the IPC state that whoever commit murder shall be punished with death or life imprisonment and shall also be liable for fine. Now here, when the death penalty case was introduced, that is the case of the Bachan Singh versus State of Punjab, a very famous case that you will be needing throughout your life. Bachan Singh versus State of Punjab, in this case, the death penalty was challenged in view of Article 21 of the Constitution. But the Supreme Court told that the Article 21 states that no person shall be deprived of his life or personal liberty, that is okay. But they added the part, the second part, that is except according to procedure established by law. The Supreme Court said that it is except the procedure established by law. So the petition of the petitioner was rejected that death penalty violate Article 21 of the Constitution, because 21 talks of the deprivation of the life, but there is a provision of the procedure established by law, and that is the death penalty. So in Bachan Singh versus State of Punjab, this is a very famous and landmark judgment of the Supreme Court regarding Article 302 of the Indian Constitution, that is death penalty, whether it is for the murder or whether it is 375 of the IPC, that is rape. Now here right to life is connected with the personal liberty. Okay, so means right to life include personal liberty, and the second is the right to die with dignity, that is passive euthanasia. Now what is the concept of passive euthanasia? A petition was filed in the Supreme Court in which it was stated that the right to life should include right to die. The Supreme Court told that yes, it should include right to die, but that should be right to die with dignity. मतलब कि if I am not in a suitable condition, then only if it is I have went into a vegetative state. मतलब कि in such a state from which it is impossible for me to return back to my normal life, in that case only euthanasia can be given to me. What is euthanasia? That is removal of the life supporting system. So Article 21 talks about right to life and right to die with dignity. The Supreme Court told that every person has the right to die but with dignity, where they introduced the concept of passive euthanasia, that when a person go into a vegetative state from which it is impossible for the person to return back, that time the medicine or the devices or the life supporting devices on which he is being held, that can be removed. And for that we have a very long concept of the passive euthanasia, that there should be the consent of the family member, or there should be a will, okay, there should be the doctor advice. So these are the things that you have to read in Clat perspective. Now this is right to life also include the Article 21 also includes the right to privacy. That was the famous case, of very famous case of K.S. Puttaswamy versus Union of India. In this case, the Supreme Court held that Article 21, that is right to life, include right to privacy. Every person has the right to privacy, and this is right of privacy which is all the time being challenged in the Supreme Court for various petitions. So the landmark case for related to this is the K.S. Puttaswamy versus Union of India. This is a very famous case. You must be knowing this. Then right to life also include the right to speedy trial. It was a case of I guess I'm not remembering the exact name of the case. Just give me a minute. Yeah, it is Husainara Khatun versus State of Bihar. Husainara Khatun versus State of Bihar. That is the Supreme Court judgment of 1980, in which it was held by the Supreme Court that right to life included that the investigation and the whole trial should be completed within a time bound program, so that the under trial prisoners, okay, the under trial prisoners right to life is not violated. This is just on the paper. We can know that even some of the 2020 batch of GNLU, they are doing a research on the same topic, that how many under trial prisoners are there. That is a very good research going on in GNLU at this point of time. So right to speedy trial will also become under right to life. That is the case of Husainara Khatun versus State of Bihar 1980 judgment. It is of Supreme Court, in which the Supreme Court told that the investigation and the whole trial process should be completed in a time bound. But although it is not possible in India, where we have crores of cases pending. So this is the whole thing about Article 21, and Article 21 has another part, that is Article 21A. That is now being it is in news nowadays very much. You must have read today Hindu editorial. There was an article on the reopening of the school, where it was discussed that how India is far behind USA, Brazil in reopening of the school. Okay, so reopening of the school is not feasible at this point of time for some parents. It is feasible for some point of for some parents. For the academy, those belong to the academic field or the intellectual field, they want the school to open because it is hampering the education. So 21A of the Indian Constitution, that is right to education. That is a very famous case of Bandhua Mukti Morcha versus Union of India. Now you will be thinking that what are the importance of this case? This case are very important for your whole judicial life. Whether you are a lawyer, whether you are a judiciary judge, or whether you are in any sector of law, these cases are very important. In Bandhua Mukti Morcha versus Union of India, the Supreme Court told that there should be free and compulsory education, okay, for all the students from the age of 6 to 14 years, as in the manner the state may determine. It is a very famous case, Bandhua Mukti Morcha versus Union of India. Article 21A, right to education. It states that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such manner as the state may by law determine. So this is the whole crux of Article 21, that is right to life, personal liberty, right to die with dignity, right to privacy, right to speedy trial. And 21A, that is right to education. We have the case of K.S. Puttaswamy versus Union of India, Bachan Singh versus State of Punjab. That is a very famous landmark judgment. Always remember it. And then we have the Bandhua Mukti Morcha versus Union of India related to Article 21. So means whenever as a very matlab, as I always tell you that I am a very big lover of the Indian Constitution, and means most of the part of my day I spent in reading the Constitution only because in this semester also in GNLU we are having this Constitution. So when means for every article of the Indian Constitution is very beautiful. You take right to life under Article 21 or whether this is Article 22. That is the protection against arrest and detention in certain cases. This is a very beautiful article. Another article you will be telling that every article is beautiful for you, but really the constitutional framers definitely we should means bow our head be in front of them. They are very matlab, such a people that they have made the constitution in such a manner. All the articles are very beautiful. Now see this Article 22. Article 22 talks about the protection against arrest and detention in certain cases. Very beautiful. It tells that first of all it tells that no person who is arrested shall be detained in custody without being informed as soon as may be of the ground for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. Very beautiful. Article 21 states that every person who is arrested by the police in the custody, he should be as soon as possible be informed that why he is arrested. You cannot keep the person कि उठा के सीधे थाना में भर दिए और वहां पे फेंका हुआ है ना, मारगिला भात खा रहा है. This is not possible. You have to inform that person that why the police has arrested you, why you are being arrested, what is the reason, and secondly that person should be given the right to consult and defended by a legal practitioner of his choice. We have Article 39A, that is the free legal aid, that we will be discussing when it comes to Article 39A. But 22 it's talk about that arrested person has the right, okay, has the right to be defended by any lawyer of his choice. And another thing is that the senior inspector of that particular police station or the executive magistrate or the judicial magistrate has to inform the arrested person that bhai sahab, you have the right to call your lawyer, your family has the right to call your lawyer, and you can consult him and he can or she can defend. This is the first part. That is, he has to be informed that why he is arrested, and secondly he has the right to consult any of the legal practitioner that he want to be, with whom he wants to be defended. Now second is state that every person who is arrested and detained in custody shall be produced before the nearest magistrate, shall be produced within the nearest magistrate within a period of 24 hours, within a 24 hour of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no person shall be detained in custody beyond the said period without the authority of a magistrate. It is also very beautiful. It tells that whenever any person is arrested, he has to be presented before the magistrate, to the nearest magistrate, whether it is the executive magistrate or whether it is the judicial magistrate. That you will be knowing when you are once in the law school, when you will be discussing the CRPC. Okay, CRPC is not much of importance to you now as a Clat student, but as a law student you should be, when you will be studying CRPC, that time you will be knowing that whether it is an executive magistrate, who is a judicial magistrate, who is a subdivisional magistrate, who has the power. This all you will be discussing in CRPC. So here it tells that the arrested person has to be presented before the magistrate between the 24 hours, and the another thing is, but it excludes the time that it takes from taking that arrested person from the police station to the magistrate house, wherever the magistrate resides. The time, the journey time will be excluded. Now if that particular arrested person is not presented before the magistrate within 24 hours, then action will be taken against the SI, that is the senior inspector of that particular police station. These are the provisions of CRPC. You don't have to know that. Second thing, it is told that the person arrested can be kept in the custody of the police. See, there are two types of custody. One is the police custody and second is the judicial custody. Okay, so the police, it can be kept under the police custody if the magistrate allow him. See, and shall be kept in continued custody only with his authority. If the magistrate allow that yes, you can keep this person for further interrogation. Take the latest example of Raj Kundra case, or take the example of Riya Chakravarti case. Always connect any article of the Indian Constitution or of the IPC or of the CRPC with the present cases. Then it will be easier for you to understand. So in the Rajkundra case or in the Riya Chakravarti case, the Mumbai police told that we want more integration from Riya Chakravarti or Rajkundra. So the court told, okay, you can keep them in your custody. You must have those who are following the live law, they must have seen that Rajkundra has been sent to 2-day police custody. Then sometime you will be getting that Riya Chakravarti has been sent to judicial custody. So police custody and judicial custody is different. That is not of your concern. So that is part 2. Now this is a very famous case of Dkvasu versus Union of India. In the Dkvasu versus Union of India, the Supreme Court has given the guideline and direction to the police station of our India, for our country, every police station, that how the arrested person should be treated and detained. What are the guidelines they should be following? You must be very aware of the custodial death. Custodial death, you must have heard that the death in the prisons. Okay, that is a very famous thing, especially in UP. There is the encounter thing is there. So custodial death is there. Now in Dkvasu versus Union of India, the Supreme Court has given a detailed guideline regarding this prisoners. What are the guidelines? What are the way in which the arrested person should be kept? What are the, if there is a custodial death, who should be responsible? Generally, we see that none of the police inspector, whether it is the SI, DSP, whatever he or she is, they are not generally held accountable. So that is the reason why there is a need, for reform in the police. Reform is required in our country. So that was Article 20. It was Article 22. With that, we complete the freedom article, in which we discuss 19, 20, 21 and 22. I hope it is clear to everybody. If anybody has any questions, they can ask, or if it is clear to you, you can write in the chat box. Yeah. Okay. Now from now here, whatever article are there, they are very simple article. They don't need too much detailed discussion. Okay, whatever discussion it will be needing, I will be doing. I will be connecting it with the present scenario also. Don't worry. But now these are the simple articles. Just we will be going on knowing what is the article generally mean. Okay. So article, now we come to right against exploitation. The exploitation of the weaker sections of the Indian society by the unscrupulous individuals or even by the state, that is defined under Article 23 and 24. Article 23 states that traffic in human being and beggar and other similar form of forced labor are prohibited, and any contravention of this provision shall be an offence punishable in accordance with law. Now beggar here what is the meaning of beggar? Beggar means here not that beggary that you see in the train or on the railway station. No. Here beggary means the involuntary work which is done without any kind of payment. The Supreme Court told that it is a fundamental right of a person, whether he is a citizen or a non-citizen. Mark my word, words are game changer, game in law. So Supreme Court told that it is a fundamental right of a person, whether he is a citizen or a non-citizen, not to be compelled to work without wages. The only exception being commonly imposed public services. For example, there is a war. I hope you must be knowing, this is a very common fact, that अगर कल को जाके जंग छिड़ जाता है इंडिया और पाकिस्तान में, the government can ask Shubham Pandey or any one of you, okay, that go and stand on the border and fight with the Pakistan people, with the Pakistan army, anyone. So if any public service is imposed by the government, in that case, that is not a beggary, the Supreme Court told, but whether it is a citizen or a non-citizen, they should not be compelled to work without wages. This is here beggary. Beggary here does not mean the beggar that you see in the railway station and the platform. That is there. Another reason not to talk on that. So it is told that see the mind of the constitutional framers. They just not limited it to beggar. They told that other forced labor. before means during the 19th and the 20th century. I am giving a very good example. That for example, take from here only. I am taking your name only. You will also feel good. Now Ankit Yadav is a labor. He is working under a factory. Ankit Yadav is a labor. He is working under the factory, and he has taken a loan of 20 lakh rupees from one of the munim of his village. Okay, and the name of the munim is anyone. Okay, for example, Amir. He has taken the 20 lakh rupees from Amir. Now Ankit Yadav died. Ankit Yadav died. Now Ankit Yadav has a son whose name was Sonu and Monu. Not, I will not take the name of from here. Sonu and Monu are the two sons of Ankit Yadav. Now, what Amir will do, he will call Sonu and Monu and tell him that you work under me until and unless your father's loan has been repaid. And there is no limit. They have to work for whole life. Sonu and Monu has to work for their whole life. Then Sonu and Monu son. Okay. Sonu and Monu son has to work for their whole life. This was the forced labor. This was the forced labor that was going on in that time. So the constitutional framework, they planned in a very beautiful way and told that it is not only beggary but all other type of forced labor which is against the human dignity. That is Article 23. Article 24 talks about it prohibits employing children below the age of 14 years in any hazardous job. No child below the age of 14 years shall be employed to work in any factory or mine or engage in any other hazardous employment. Now, इसका मतलब ये नहीं कि your father or mother is telling you to go and buy vegetable from the market, okay, or they are asking you to give them a glass of water. That is not employing children. It is clearly mentioned that to work in any factory or mine or engage in any other hazardous employment. Even if your father and mother tell you to sit with them in their business, they are having a very big business of cement, for example, or medicine, and it's the time of coronavirus. There are a lot of people in your customer in your shop. The shop has to be kept open till 11 p.m. at night. There are many staffs, but still your father is not able to manage. Now your father tell that come and sit with me in the shop. You don't have to sell the medicine, just count the money, do the calculation. So that you cannot challenge that. You cannot go to the Supreme Court or the High Court and tell that this is a violative of Article 24 because I am less than 14 years of age. My father is employing me. No. It tells that no child below the age of 14 years shall be employed to work in any factory or mine or engage in any other hazardous employment. That is the thing. So Article 24 is clear. That is the right against exploitation. Now we come to the right to freedom of religion, one of the very controversial article of the Indian Constitution, and it is in view of this right to freedom of religion many things. The most prominent is the Uniform Civil Code. The most prominent is the Uniform Civil Code. Then the conversion of the religion. Okay, the love jihad case is there. The conversion of the religion. Then the use of the loudspeaker. Okay, in the mosque and in the temple. So this all thing are used under Article 25 to 28. That is right to freedom of religion. India is a secular country, so the state has no religion of its own choice, and the people are free to propagate their religion, practice their religion. And so this is one of a very controversial article. So we will also not discuss much on this. Again, we will be entering into controversy. Now come to Article 25 directly. Article 25 says that subject to public order, morality and health. This is a very famous question of polity. Polity, whenever I tell that it is MSCT, BHU, Clat, Judiciary, UPSC. Subject to the public order, morality and health and to other provision of this part. Of this part का मतलब होता है fundamental right. That is part 3. All persons are equally entitled to freedom of conscience and the right to freely, the right to freely profess, practice and propagate their religion. If you are not going, if the religion that you are propagating or you are practicing, if it does not go against the public order, morality or health, then you are entitled to practice, profess and propagate any religion of your choice. Now, Article 25 has a very important explanation that is not written there, but it is a very important explanation that is in Article 25 is the wearing and carrying of kirpan shall be deemed to be included in the profession of the Sikh religion. Okay, it was challenged in the Supreme Court that the Sikh people, the Sikh people carry kirpan. This is a very common thing. Even when I was in class 11 and 12, one of my friend, okay, she used to carry the kirpan. The first day she came to school, I saw it, and then I remember the Article 25 of the Indian Constitution, the explanation. So this is the thing, you should connect everything with your present day life. Okay, so I saw that she was carrying the kirpan, and then I remember Article 25 which state that the wearing and carrying of kirpan shall be deemed to be included in the profession of the Sikh religion. It was held. That is Article 25. That every people has a right to practice, propagate, and profess any religion of their choice. Now, Article 26. Article 25, there is no more thing. The Supreme Court told that, Supreme Court has told in means related to Article 25, a very important thing, that whatever you are practicing, whatever you are propagating, it should be something that is very essential to your religion. That I don't remember the case as of now. I guess, just give me a minute. I guess it is the Ismail Faruqi versus Union of India case of 1994. Whatever it is, leave it, no problem. In that case, Supreme Court has told that mosque is not an essential part of the practice of religion of Islam, and namaz by Muslim can be offered anywhere. Okay, Supreme Court told that it is not compulsory that namaz should be held only in the mosque. It can be held anywhere, and the mosque is not an essential part of the practice of the religion. So Supreme Court told that to propagate, practice your religion, that particular thing should be an essential part of your religion. That is the thing. So I guess it is the case of Islam Faruqi versus Union of India. I will check it and tell you once. Now Article 25 it is over. Then we have Article 26. Okay, I guess someone has put a chat box. There is something in the chat box. No. Sabrimala case is something different, Pankaj. What you have written just now. Sabrimala case is something different. Sabrimala is related to the entry of the women who are in the menstrual period. Those who are in the menstrual period. That is another thing, though we will not be discussing this whole thing because it is a very controversial issue. Okay, you can see even the Supreme Court has referred it to a very large bench, and there is nowhere they are taking up the case. मतलब वो refer कर दिया large bench को, but they are also not taking the case because they know it is a very controversial matter that is related to public order, public demand, and that is related to law and order. We will not be discussing that. Now we come to Article 26. Again, it tells that subject to public order, morality, and health, every religious denomination or any section shall have the right to establish and maintain religious or any charitable institution. Okay, they have the right to manage their religious affairs, their institutions, and they can use any property for that. That is Article 26. Just that only you have to know. Article 27 states that it provides freedom not to pay taxes for religious expenses on the promotion or maintenance of any particular religion. No, there is a difference between taxes and chanda. Taxes, chanda, and fees. Supreme Court has very clearly held in Durga Committee Ajmer versus Sayyid Hussain Ali. You don't have to remember the case. That is a 1961 Supreme Court judgment. Supreme Court told that there is a difference between taxes and chanda, that is regarded as a fees. Article 27, which is talking about, it is talking about that no taxes should be taken from the person, but is not taken. It is the freedom of the person. If he does not want to pay the tax, no issue. Just see the latest example of Ayodhya, the Bhavya Ram Mandir. Okay, they move from every door to door and ask for chanda. Now, if any person will not tell that I will not give you the chanda, then you cannot compel him. You cannot compel him that you have to give the chanda for the Ram Mandir. People generally give it for the sake of the Ram, in the name of your God, but you cannot compel any person that you have to give. So it provides freedom not to pay taxes for religious expenses on the promotion or the maintenance of any particular religion. You have the freedom. If you do not want, you do not give. Now you don't do like that you go to, अब ऐसा मत कीजिएगा कि आप लोग सीढ़ी गए, या फिर you go to Vaishno Devi and there the pujaris are asking you to give 10 rupees, then only they will allow you to enter into the mandir, then you don't start telling that I am a law student and I can use Article 27 of the Indian Constitution that it provides freedom not to pay taxes. Don't start doing this, because I have seen many of my friends, but once you come to the law field, no, you think you are a very, matlab, you're a very powerful man, you have the every right, you have the very every articles, IPC, CRPC. So even if something happen on the road, this law student and especially the first year law student, they use it and they show that I am a law student. So don't do all these things. Just it is in the Article 27. Just remember that you cannot be compelled to pay taxes for religious expenses on the promotion or the maintenance of any particular religion. The last is Article 28. Okay. No religious instruction shall be provided in any educational institution wholly maintained out of the state fund. This is very important, guys. It is wholly maintained by the state. Because if it is an minority school, for example, the you must have heard the Saint Joseph schools or the convent schools, है ना, Saint Joseph convent हो गया, then you have the Javiers, okay, then you have the madrasas are there, है ना. These are not maintained by the state. So Article 28 is that it prohibits religious instructions in educational institutions which are maintained by the state, that are maintained by the state, in that wholly maintained out of the state fund, in that no religious instruction can be given, है ना. Yeah. So that is Article 28. So this is all about right to freedom 25, 26, 27, 28. This is a very controversial article. It is always in news and reports. Now we come to cultural and educational right, that is Article 29 and 30. Okay. 29 and 30 is the cultural and educational right. So any section of the citizen residing in the territory of India or any part thereof having a distinct language, script or culture of its own shall have the right to conserve the same. It provides for the interest of the minority, and it tells that any of the section of the citizen residing in the territory of India, they have the right to conserve their language, their script, their culture. I give you a very famous example of the Apathani tribe. Apathani tribe is in the Arunachal Pradesh. Okay, so we have done a research on that tribe in the last semester, I remember. Okay, so they are having the swapping of the nose and the ears. Okay, you will search in the Google, you will be getting that. They were having a tradition, that tribe in Arunachal Pradesh or Andhra Pradesh, I don't remember perfectly. Okay, they have the tradition coming from generation of the swapping of the nose and the ear. So, well, in the research, there was a woman who was telling that now this tradition is slowly it is getting over, because this generation girls, they don't want to swipe their ear and their nose. Okay, they don't want to swipe their ear and the nose, and she was very sad. It was shown that she was very sad. So that is your culture. I give you the example to show you that the community, any citizen, they have the right to conserve their language, script or culture. Another thing is there in Article 29 is there that no citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of the state fund on ground of only of religion, race, caste, language or any of them. If it is a madrasa, if it is a minority school which is not aided by the government, for example, the Saint Joseph convent is there, Xavier is there. In some, for example, the Saint Xavier Rachi, if anyone is from Jharkhand, the Saint Xavier Rachi, it is aided by the government. So there also you cannot be disallowed from getting an admission on the basis of your caste or on the basis of a religion. But the minority school or those who are they are establishing the institution for their religious purpose, they can deny you the admission if it is not either fully or partially aided by the state. The moment, even if it is partially aided by the state, in that case they cannot deny you the admission. So that is Article 29. Then we have the article then we have the Article 30. Article 30 stated all minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. It's still that the right of the minority, whether based on religion or language, they can establish or administer educational institution of their choice. Now, what is a minority? It is a very famous case of Kerala Education Bill. है ना? You must be knowing this case. There is a case related to Kerala Education Bill of Supreme Court in 1957. In this case, the Supreme Court held that what is the meaning of minority? Supreme Court told that the Supreme Court has observed and decided cases on the basis that it referred to any community which is numerically less than 50% of the population of a particular state as a whole. The Kerala Education Bill 1957 case, the Supreme Court told that whoever population is less than 50% numerically in a particular state, they will be considered as a minority, and they have the right to administer, they have the right to administer and establish educational institution based on their language, based on their education, based on their religion and language. So this is your cultural and minority right, that is article 29 and 30. Now we come to the last part of the fundamental right, that is right to constitutional remedy. There are article 32 to 35, only two articles you have to remember, that is 32 and 35 only. Here we have very important topic will be coming, a very beautiful concept of our constitution. Every topic is beautiful of the constitution, whichever topic you take up, just yeah. So see, article right to constitutional remedy. Now this just I have not written it there. I guess शायद नहीं लिखा हुआ है. Let me see if it is in the it is written there. That only I thought that how it is not written. B.R. Ambedkar has stated right to constitutional remedy as the heart and the soul of the Indian Constitution. This is a very famous question. Whoever are preparing for MSCT, BHU or judiciary even, they must have got this question a numerous times. You take any polity book, this question are at least 50 times in the whole book. At which article of the Indian Constitution was regarded as the heart and the soul of the Indian Constitution by Dr. B.R. Ambedkar? It was article 32, that is right to constitutional remedy. Now we will be discussing what is article 32. Very good. Article 32. Now whichever article 31, I hope you must be knowing, that is right to property, which was repealed by the 44th amendment of the Indian Constitution. Okay, you don't have to know that, right? Though that article. See, what does article 32 state? The right to move to the Supreme Court by the appropriate proceeding for the enforcement of the right conferred by this part is guaranteed. The Supreme Court shall have the power to issue direction or order or writ, including writ in the nature of habeas corpus, mandamus, prohibition, quo warranto, certiorari, whichever may be appropriate for the enforcement of any of the right conferred by this part. Any person has the right, if your fundamental right is violated, you can move to the Supreme Court or the High Court. Supreme Court, article 32. So because we are discussing article 32, so I am only telling about Supreme Court. When it will be coming to article 226, we will be knowing about High Court. If any of your fundamental right has been violated but by the state, always remember, you will always be seeing that all these cases are what? Bachan Singh versus State of Punjab. It is not Bachan Singh versus Priyamvada Nima. Okay, it is, for example, you take the whether you take Shreya Singhal versus Union of India. It is not just Shreya Singhal versus Shubham Pandey. That is not the case. All the time it will be state, and we have discussed in under article 12 what is state. So if your fundamental right is violated by the state, you can move to the Supreme Court under article 32 and 226 High Court for the enforcement of your fundamental right, heart and the soul of the Indian Constitution. Now the Supreme Court, for this purpose, this is very important, you have to remember this for your whole life. Okay, when you become a successful lawyer, you will be asking the court to issue this writ. That time you will be remembering lighting dreams. For this purpose, the Supreme Court can issue writ of 5 types. We will be discussing. I hope you are noting it down, all this point. The first is the habeas corpus. Now, habeas corpus in a single word means to have a body. What is the meaning of this? For example, if you are illegally if you, if you are illegally detained, if you are illegally detained, then a petition can be filed. For example, I am giving you an example. See, we will be discussing two things here. First is that the police has taken you to the custody. They have kept you under them. They have not told you what are the ground on which you are arrested. They have not allowed you to discuss your matter with any of the magistrates. They have not allowed you to means they have not taken you to the near magistrate within 24 hours. Now your father filed a petition in the Supreme Court that, sir, Honorable Justice, that please issue the writ of habeas corpus as my child has been detained illegally or arbitrarily. So that is the meaning of habeas corpus. So this is not only against habeas corpus is not issued only against the state. Okay, it is not only issued against the state. For example, I give you a very practical example that if for example there is A is the father and B is the daughter. A is the father and B is the daughter. There is a marriage fix of B with C. Now, on the day of the marriage, B has eloped with somebody else, try, trying to elope with somebody else. है ना? Now, in that case, the father A can file a petition in the Supreme Court against D that please issue habeas corpus as my daughter has been illegally detained. She is not allowed to come out of the confinement. That is a very famous case because why I am giving you this example, I don't remember the name of the case exactly, but it is a very famous case of the Supreme Court in which one of the daughter was held in confinement within the four walls of a room by her father. The father was not allowing her to come out of the room because of this similar situation. In that case, the D, whoever is the D for the D has filed a petition in the Supreme Court for her that the father has kept her in confinement. In that case, the Supreme Court has issued the habeas corpus writ and asked the father to release that girl as soon as possible because they were above the age of 18 majority. They were more than 18, so they were in the majority. So the father was asked to release that. So that is habeas corpus to have a body. Second, we have the mandamus. Mandamus is related as V command. V command का मतलब हुआ कि if the government authority, for example, if you want to buy you're buying a plot of 5 acre, okay, and you went to the registry office and you asked the particular concerned authority that, sir, please do my registry. Okay, he told, okay, you come to this date, I will be doing the registry. You went to that date, he again postponed and again postponed and again postponed. Now you can move to you can move to the Supreme Court. Okay, you can move to the Supreme Court that this particular government official is not doing his work properly. Please issue him the writ of mandamus. Similar is the case of the voter ID. For the voter ID, you can move for the mandamus, or where the government is not working properly, where the government authority, here government does not mean the central government only or the state government. The government authority is not working properly. In that case, you can move to the Supreme Court or the High Court under Article 226 and ask them that, sir, issue the writ of mandamus. Then we have the prohibition. Prohibition is something. For example, there is a district court. Okay, let's take the case of the Consumer Protection Act because you have read in Clat 2021. Most of you have read in Clat 2021 the Consumer Protection Act. For example, there is I don't remember exactly the amount, but for the district court, for example, we are just imagining that for the district court the amount is 20,000. The district court cannot take a case above 20,000, for example. Now you have taken a matter to the district court. The district court has heard the matter. The district court has given the decision. The district court has given the decision, or the trial is going on. For example, Priyamvada has filed a petition in the district court, which is having the jurisdiction of only 20,000 rupees against Pankaj. Pankaj is one of the businessman. Okay, so that is a consumer protection under the consumer protection case again the district forum. A case has been filed by Priyamvada against Pankaj. Now, while the trial is going on, or while the trial is going on, or the decision has been given by the district forum in favor of Priyamvada. What Pankaj can do, he can go to the to the state forum, which is having the jurisdiction of 1 lakh rupees, and tell that Honorable Justice, the petition that was filed by Priyamvada in the district forum was of worth of 40,000, and the district forum was having only of 20,000 pecuniary jurisdiction. So how can the petition which was taken into consideration by the district forum, how it can be tried by that court? You have to cancel that order. The High Court will issue the writ of prohibition and ask that court to immediately, if it has given the judgment, that judgment will be quashed, or if the proceeding was going on, he will tell that immediately stop the proceeding. Immediately stop the proceeding. Is this example clear, or I will repeat once again? Everyone? Pankaj and all? Priyamvada, Amir? Yeah. Is the example clear? Yeah, very good. Okay, once again. Definitely. It was something complicated. So see, I'm giving you the example once again. Prohibition is prohibition is generally in terms it means that from exercising jurisdiction which they do not possess. When you will be moving to, for example, in the GNLU in the second semester, or in the NLU Assam it is in the third semester, in the third year, then in Jodhpur NLU Jodhpur it is, I guess, in the whichever year or semester it is, you will be getting CPC. In the CPC we talk about jurisdiction. Okay, Code of Civil Procedure, we talk about jurisdiction. So prohibition का मतलब हुआ कि, for example, I am telling you that, taking the example of Shubham and Kinjla. Shubham is a customer and Kinjla is the businessman from which Shubham has bought any article which is worth 60,000 rupees. Understand very clearly. It is very easy. Okay. Shubham has bought an article from Kinjla whose cost is 60,000 rupees. Now there is some defect, and I presume that most of you, means all of you, must be knowing the Consumer Protection Act. Now Shubham goes to the district forum which is having the jurisdiction of only 40,000. They can try the case of only up to 40,000. But Shubham go and file a petition in the district forum that, Honorable Justice, I have been cheated by the businessman Kinjla. I want you to take the petition, acknowledge the petition, and do the necessary proceeding. Now, when the trial is going on, or the district forum has given a judgment, after this or during the trial is going on, Kinjla can move to the state forum which is having the jurisdiction up to 1 lakh. The state forum of the Consumer Protection Act has the jurisdiction up to 1 lakh. She moved to the state forum and tell that, Honorable Justice, Sumam Pandey has filed a case in district court, with the district forum, not the district court, district forum, which is having only the jurisdiction, pecuniary jurisdiction. Pecuniary means the amount of jurisdiction. The pecuniary jurisdiction of that district forum is only 40,000, and the worth of my article is 60,000. I request you to issue the writ of prohibition. The High Court, in this case the state forum, will issue the prohibition and ask the district forum to immediately stop the matter, or if it has given the judgment, immediately it has to quash the judgment, because that particular district forum or that High Court do not have the jurisdiction to try this case. Now it is clear to everybody? Shubham and Sindhuja, yeah. Okay. Next we come to the certiorari. What is certiorari? Now certiorari is the similar thing to prohibition. Don't get confused between certiorari and prohibition. Certiorari is for the prohibition we discussed that while the trial is going on or when the judgment is given. But certiorari is what? Certiorari states that when the trial is going on, at that time only the higher court will ask the lower court to transfer the record of the case. Again we will take the example of jurisdiction only, don't worry. Okay, jurisdiction example we will take, that is pecuniary jurisdiction, that is the amount jurisdiction. Okay, don't take amount jurisdiction. Let's go to, for example, let's go to territorial jurisdiction. What is the meaning of territorial jurisdiction? That whether that particular case come under your territory or not. Okay, territorial jurisdiction means, for example, if you file a petition, for example, let me take someone name. Okay, Yeah, we have Sejal and Sindhuja. Okay, very good. We have Sejal and Sindhuja. For example, Sejal filed a case in the district court of Gandhinagar. Okay, for a petition, for a cause of action that was between them, Sindhuja and Sejal. But that particular district court of Gandhinagar do not have the territorial jurisdiction to try this case. Now, what Sindhuja can do, she can move to the Gujarat High Court and ask the Gujarat High Court to issue certiorari, where the court, Gujarat High Court, will ask the Gandhinagar District Court that you do not possess the jurisdiction to try this case. Immediately you transfer the record of this case to us. Immediately you transfer the record of this case to us. It is we who will be deciding this. So that is the rate of the certiorari. It is clear? Certiorari is clear to everyone? The higher court, it is not only high court, even the Supreme Court can ask the high court. The high court can ask the subordinate court. Okay, the district magistrate court first division can ask the district magistrate court second division. So what is district magistrate court first division, what is district magistrate court second division, you will be doing when you will be studying CRPC. That is another thing. The last writ that can be issued by the Supreme Court or the High Court is quo warranto. Quo warranto in the another name is by what you hold your office. By what you hold your office, the court will ask you that by what power you are holding the office. For example, take the example of the recent cases of the, I guess it was the state of Jharkhand or something, which state, in which at least 4 lakh job of the teacher or something was struck down by the court because they were having false certificate. I don't remember the state exactly, but there is something. Take the example, imaginary situation. For example, there is the state of Jharkhand, and the teacher has been admitted in 2018. In 2018, 4 lakh teacher were admitted, and the para teacher that you tell, the para teacher, government teacher that you tell. Now, in 2021, the petition was filed in the Jharkhand High Court that these people have fake B.Ed certificate. The criteria for the eligibility criteria for to become teacher in that 2018 case was that the teacher must be having a B.Ed certificate. Now, a petition was filed in 2021 on 10th of August 2021 that they are having fake certificate. Now, in this case, under Article 226, the High Court, or if they move to the Supreme Court under Article 32, in that case the 32 Supreme Court or 226 High Court, they will issue the writ of quo warranto and ask the public authority of that particular teacher that by what power, by what virtue you hold the office. And if your certificate are fake, if it is proved in the court that your certificate is fake, you do not have the power to hold the office, immediately you will be terminated from that particular office. That is the writ of the quo warranto, which asks that by what you hold the office, by the virtue of what, by the power of what you hold the office, that is your quo warranto. So these are the 5 writs that is issued by the court, whether it is the Supreme Court or the High Court. Since we were now discussing Article 32, so it is this. Just last article, let's complete the fundamental right. Article 35, just last very easy article, nothing to discuss. Parliament shall have and the legislature of the state shall not have the power to make laws. Here in Article 35, it is in concern with the central list, in which it tells that it is the Parliament which will be having the power to make laws on any subject in the central list, and it is not the state which will be having. This is not an important article. So this was all the important fundamental right, Article 32, which is called the heart and the soul of the Indian Constitution. These were all the important fundamental right that one should know. We stop here and we will meet tomorrow.